All right, so Mr. Stubbs, it looks like you are wanted out of Alabama for,
The possession of marijuana first degree felony.
wow.
Because of the amount. It didn't
Is
say,
it a capital weed case?
I don't know how much it is, Judge.
Yeah. So it looks like you're wanted for a first degree possession of marijuana case. What would you like, Miss Oko?
Pause for a second. First degree possession of marijuana? That's not a casual oops, I had a little baggie. In Alabama, that's a serious felony. Viewers, would you have guessed a weed charge could carry that much weight? Drop your thoughts in the comments.
Been set according to his bonds lady, and this would have been the second one, but due to issues happening with the court itself, there is a change of staffing at the jail, according to the bonds lady. And so they had issues with court resets, and they sent out wrong court dates, and people just didn't make those court dates because they never got it. And that's why Mr. Stubbs is here today. He is more than capable of going to his court date in Alabama, taking care of this warrant, and he does hope to get his bond renewed in Alabama because this was a mistake on their end. So he just wants a low bond so that he can pay it, take care of Alabama, and then come on back to his family here in Houston.
Do you have a lawyer in Alabama?
Somehow my lawyer got sick. Somehow he got sick and he was taking off my case. So instead of them sending my case to someone in the law firm with him, somehow I was appointed a court appointed.
And I know the new name.
What I would suggest, the thing is though, is that if they made a mistake, then many times they'll own up on the mistake and reinstate and release the hold.
That's what the lawyer was trying to get the hold released, him and the bondsman. They've been working together to try and get it released.
So what I would do is use, because now here, I don't know if I'm gonna give you a bond, Mr. Stubbs. I gotta tell you that I take this extremely serious, right? I don't know you. I've never met you before. Everybody that comes over here tells me it's little bunnies jumping in the woods and rainbows and gumdrops, but when they get out, they turn into a...
This is classic courtroom tension. The defense paints a picture of an honest mistake, but the judge is locked in on public safety. And remember, judges don't just weigh excuses, they look at patterns. Do you think the judge is being fair here, or too harsh?
That I have had, I don't care where I'm at. If I have to drive 1,000,000 miles, I would drive 1,000,000 miles to show up for court because I don't want to be in this position. First of all,
in and out for some reason, and I don't know why.
But mistakes courts made.
Tell me, how long has this warrant been open?
The warrant's been open since January 2024. It was a month before he picked up 2 felonies in our jurisdiction, impeding breath for a family.
So that warrant's been open since January?
Yes, Your Honor. And then a month after, he picked up 2 felonies in our jurisdiction, and assault family member, impeding breath, and evading motor vehicle. He said 3 failure to ID out of 2 different jurisdictions, and he had a prior fugitive case in 2006. Because of all those factors, I believe he's the definition of a flight risk. He literally drove away from the police and failed to ID himself at least 3 different occasions.
Yikes. This is where the past really catches up. Assault, evading arrest, prior fugitive charges. Suddenly, this isn't about one missed court date. It's about a whole track record. Quick legal insight. Prosecutors bring up these priors to argue someone is a flight risk. Basically, too risky to let out on bond.
This warrant from Alabama has been open for a year.
It's been open for 3 years.
No, the warrant that was been issued in this case. You've had an entire year to take care of this.
I never knew about the warrant because my bondsman wasn't contacted, nor was I contacted because the lawyer fell off the face of the earth.
It's your responsibility. No one is going to call you, hey, Mr. Stubbs, it's time to take care of this criminal case. Come on, man, it's time to take care of it. Criminal cases don't work like that, man. When you hire a lawyer, you hire them to defend you, And, you know, the more money you spend, the better representation you get, and the more you pay to get babied, right? Like these really grandiose lawyers, they will baby the heck out of you, right? Because you pay for it.
All the courts basically, and every day until they tell me I have a new court date, or my lawyer.
Yeah, if that's what it takes, then yes.
But Judge, and I wanted to say in his defense, the bonds lady did state that he had been in contact with her as per the new court date, whatever new court date was set out. And when they issued out the court date, she didn't know about it until he missed it. He didn't know about it until he missed it. He has been in contact with his bonds lady in Alabama. What I can do is I can reach out to his attorney. I believe his name is Chris Albert. I will reach out to him in Alabama and see if I can get some sort of written correspondence from a prosecutor in Alabama. That way they can kind of rectify this whole thing.
I just, not only do you have 2 open cases here, but you've also said he picked up other cases in other states as well?
No, I'm saying he has history in 4 other states. He's had
history in 4 other states?
Yes, Your Honor.
You know?
I'm not from Texas. I just moved here. I mean, I haven't been in trouble in over 12 years, you know.
You've got 2 open felony cases. It's been open since February.
Take them to trial right now today, because when those allegations, I was in jail.
Dude, don't talk about the cases.
Trial now. I'm guilty to prove innocent, right?
Let's do this. Ms. Chisholm, can we roll it to tomorrow? Will you reach out and see if it is a true error in their part? Maybe
Absolutely.
Release the hold?
Yes, Judge.
I don't feel comfortable. This thing's been open for a year. You've known it's been open for a year. I mean, and now the only reason you want to take care of it is because we got you, when you should have
I never
been
knew
proactive.
I never knew I had a warrant.
It's okay. And Judge, I'll get some written correspondence. Hold on, Mr. Stubbs, hold on. I'm gonna get some written correspondence to that effect. That way we can have something on paper. And if we can't get it on paper, then we'll take it on from there. But I'll do my best to reach out to Alabama folks.
Mr. Stubbs, she's great. That's why we have her working with us to try to help resolve these issues. You know, if they can, hopefully they'll release the hold.
Yes, Judge. I'll start working on that now, but we'll roll it till tomorrow.
Yeah, okay.
So I will have to come back to court tomorrow.
Yeah.
So I will be deprived of sleep, held under duress, and still have to go through the same. I haven't eaten since Wednesday.
You haven't eaten since Wednesday?
Don't eat meat. They only bring you bologna sandwiches. I'm tired of going through it, Judge. I don't do anything
I don't know
wrong.
if they have
I haven't been in any trouble.
They have vegan stuff.
This part is tough to hear. Complaints about food and conditions in jail. Now, here's the thing. Inmates do have the right to basic nutrition, but whether they get proper meals, especially vegan or religious diets, depends a lot on the facility. Viewers, should courts take jail conditions into account when deciding bond?
In the commissary, I've been here a week.
Oh, you just got arrested?
I just got arrested I just got here last Wednesday. I was extradited from Dallas County to here.
Oh, so you weren't even here in Dallas?
I wasn't even here, so I did 10 days. They actually had dropped the warrant. Somehow I have a fugitive charge with a new case number that's not even the case number in Alabama.
That actually makes sense, because we wouldn't have filed ours unless he made bond and we had no other interstate, so that makes sense.
And I tell you, it's going to continue to happen eternally until you get back over there.
I mean, I think my lawyer died, so that I heard. I have a paid lawyer. I feel that my case should have went to...
If you got a paid lawyer and they dropped the ball, then you need to go file a complaint with the state bar.
I just found this out.
Mr. Stubbs.
This is a shame. It's unfortunate that you have you've one violation after the other. At some point, it's going to catch up to you, and it's going to be at the worst possible time. Something is going to be going on in your life. Something's going to happen. Criminal cases usually tend to pop up and people catch them at the worst possible time. Shh. This is going to go on your record. It's going to be there for the rest of your life. And I want you to understand, if you're ever in a car and you get pulled over and you have any kind of funky smell, they're going to see this. what do you think they're going to do to you? Right. Even if you've had a sip of alcohol, a toke, even the slightest, I wouldn't ever get in a car because you're begging for trouble. From now on, what we're doing today, you're facing now a minimum of 30 days in jail. If you're not smart enough to consider how to get home on a night of drinking, I will treat you like a child. I will put you over my knee like a child, and I will spank you like a little child. But I will do it with a ton of jail time. Do you understand?
Sir.
It's not hard. Every day, someone dies from a DWI in our county. Every single day. It's a shame. And it's so preventable. One button, $30, wherever you want to go in the city, don't matter where you want to go. Use it. You're charged with driving while intoxicated. You're facing up to 6 months in jail and/or a $2,000 fine.
This right here is a masterclass in judicial scolding. Notice how the judge shifts from weed and missed court dates to hammering home the dangers of drinking and driving. It's part lecture, part warning shot. Real question, do you think speeches like this actually change behavior, or do people just tune them out?
Under federal law, you give up the right to appeal once you accept this agreement. There's no turning back. You can't change this. Do you understand?
Sir.
Here's the thing. You have to be punished somehow. Because I want you to understand that we mean business. And I don't think that there's any bigger way to punish someone than to hit them where it really hurts.
Sure.
Number one is jail. Number two, the pocketbook. You will be required to pay the fines and fees in this case. And if you don't, every $100 that you owe, you will sit in jail. I cannot possibly let you go the way that you have comported and the way that you've acted yourself these last 6 months or however long that you and I have been dancing. It's unacceptable.
Yes, sir.
And I want you to understand that we mean business. And if you don't pay it, you're going to owe somewhere like $3,500 right now.
Yes, sir.
And if you don't, $100 in jail, you will sit for 1 day for every $100.
Yes, sir.
You understand?
Yes, sir.
I'm going to suspend your license for 90 days. That is the minimum. Do not drive until you get a license. Otherwise, you're going to be right back over here. A suspended license is a Class B, just like a DWI. Don't drive. The worst possible thing you can do is drive. Mr. Reyes.
Yes, Your Honor.
I want you to thank your lawyer, because I'm going to tell you now, any other person that would have dropped you like a bad habit, but he has been nice enough to stay with you this entire time, no matter how many times he's had to put up with your behavior, not to mention, who knows if you even got any money for this case, you know? So you're lucky that you have him even here with you. How do you plead with the offense? Guilty or not guilty? I'll find you guilty. I'll send you the agreement. Good luck, Mr. Cabrera.
Thank you, Your Honor.
Thank you, sir. So I'll roll the court cost, but I wanted to pay the DPS fine, $3,000. Yeah. Listen, I'm giving you a lot of time to pay, but don't stop, because if you do, you will be doing a lot of time in jail. And this isn't the one where you just bond out and you get, no, 100 for every day in jail. I'm going to waive the court costs, but you're going to be doing the other one. You understand?
Yes, sir.
All right, man. Good luck.
Thanks, Judge.
Got to get through to him somehow, Mr. Reyes.
You're right.
90 days.
You don't need to say a word.
Good morning, Mr. Bayo. You speak English, right?
Yes.
Okay. Shh. All right, Mr. Bayo, you're charged initially as of, it looks like November 7th, you picked up an assault of a family member. I see now that you've picked up a new case. As of November 30th, you've picked up a violation of a bond condition or protective order. I don't know which it is. All I know is that you picked up a violation case. You're facing now another year in jail and or a $4,000 fine. I haven't done probable cause, so we're going to do that. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. Sir.
Officers were dispatched to a residence in Harris County, Texas in response to a disturbance.
The complainant stated that he was locked out of his residence by his ex-wife's new boyfriend. Complainant went to the residence because his ex-wife had called them and stated that she was going to work. When the complainant asked who would be watching their children, the ex-wife said a friend. Complainant then heard defendant's voice in the background and went over to the apartment. Complaining witness is the same complainant.
You said he heard whose voice?
The complainant heard the defendant's voice in the background. I think that the complainant believed that the defendant would be watching his and his ex-wife's children, and that's why he went over to the apartment. Complainant is the same complainant from a pending AFM, and the apartment address where the defendant was staying is listed on a signed order of protection.
How bad of an assault were we talking in the original case? What happened?
I think it was punching in the face with a closed fist.
Once, twice, thrice?
2 to 3 times, it looks like, Judge.
Okay.
And I can give some excellent background on that I think they're also still working through.
On the assault case, we issued a protective order, I would imagine.
Yes, and I've got a copy of that, Judge, if you need to see.
And did we order him not to have contact with this person?
Yes, but that's not the basis of the new charge. And so if we delve into the state's filed information, which is also the basis of the allegation that he violated, well, I imagine you're hearing both kind of in conjunction, the new charge PC, but also considering the questions of bail with respect to the first charge as well.
Of course.
What's been alleged in the new information is that Mr. Bio went to the residence of the CW, Mr. McWilliams. As of the date when we first appeared in court, the representation was made by both Mr. McWilliams, and then today the representation was made by the ex-wife of Mr. McWilliams, who is the dating partner of Mr. Bio. So he is dating this gentleman's ex-wife. But she has confirmed to both of us that McWilliams has moved out of that residence as of the date of the first alleged assault. And McWilliams has told them that. They have been unable to reach McWilliams as of recently, but in the writ call information, McWilliams confirms, I moved out that day and do not live at the address that's at issue in this VPO case. If you look at the filed information in that VPO case, it's a necessary ingredient of that allegation that McWilliams lived at that address. It specifically says it in the last line.
You're saying in the protective order?
Yes, Chair. No, not the protective order. In the violation of protective order case, if you look at the state's filed information in that case, you will see the last line is, to wit, he was at the complainant's residence, but Mr. McWilliams doesn't actually live there. He moved out. Actually, was not on the lease.
He's still not supposed to have contact with this person.
He's not. He didn't have contact with him. What happens is he's at a place that is not McWilliams' address, and then McWilliams, angry that he's there, still wanting to control his ex-wife, comes over there and busts the windows. And so that is
What's the window of
his ex-wife's house where Mr. Bio.
What's the ex-wife's name?
Shannon.
Okay, so.
And we both spoke to Shannon a few minutes ago.
And Shannon has how many kids with Mr. Bio? Or do they have kids or no? So whose kids are they? McWilliams?
McWilliams and Shannon's children.
Okay.
I think there's 2.
And so what's alleged in the newly filed charging document is that Mr. Bio went to the residence of McWilliams, which there's no PC to believe that. He did not go to the residence of McWilliams. He went to Shannon's residence. McWilliams does not live there, stopped living there, and the state can't meet the information. And so there's no PC on. My argument, Judge, is that there's no PC that the state or the officer.
So in our case, in the assault case, the protective order says that he's not supposed to go to this Spring Cypress the apartment in Spring Cypress, right?
Well, contemplating that that's McWilliams' address.
Is that his address? Yes or no?
That is no longer his address, Judge.
Okay.
When that was filed, I imagine that was the original apartment, but on the
Because a lot of
day,
times they never updated, they just put the original apartment where it happened at, and they always assume that it's this, and, you know, just,
so that's no longer the address. Mr. McWilliams moved out of that address on the day of the incident, and he told
Okay.
me he moved out. I believe that Shannon is the only name on the lease.
for the violation case, where is he alleged to have gone to?
He went to the address that's listed in the original MOA. So he went to the Spring.
Spring Cypress.
Right.
That's right.
Okay,
And
but what he's saying is that this person no longer lives there.
well, that's what McWilliams told the state. And that's what Shannon has told both the state and myself. And that is what our full understanding is. Now, I know that address is listed in the protective order, but what's contemplated by the protective order is don't go to a place where McWilliams lives. And McWilliams is not living at the Spring Cypress.
The problem is that we also have this address there because he could always go back.
Well,
He may not live there. Maybe he lives there partially. Maybe he comes and goes.
but what told us was he was
is
kicked out.
also as a preventative measure so that we don't want you to actually or accidentally bump into this person. And that's why we have this there, is that he did live there at one time. Perhaps he may go back. He left an article of clothing. He left pizza there, or whatever it may be.
Well, what's really happening is he wants to go back and continue harassing his ex-wife. And that is what Shannon has represented, I think, to both of them. I wasn't privy to their phone call. Certainly what was represented to me. And,
What do you want?
well, I want no PC to be found on the violation of protective order charge because an element of that offense that's been alleged is that Mr. Bio went to the residence of McWilliams. McWilliams does not live there. It's not his residence. So there's no PC to believe that that element is met.
What do you think?
Judge, I don't know, on this matter,
I gotta think, it's expressed in the order. In the order is that address was PC, but the actual information.
I will say, Judge, in the charging instrument, the defendant it does say, he's not allowed to intentionally or knowingly go to a place specifically described in the order. The address in the order, that's where he was staying. But in terms of
The address in the order, who was staying
the defendant was staying at the address in the order.
in this
In the
protective
original
order?
MOA, Spring Cypress.
Okay.
The defendant was staying there. But I will say in terms of PC, I'm going to defer to the court on this matter.
May I just read that little blurb of the information that I think is important for the court to hear? May I take a, yes, cheat and steal y'all's computer? Yeah, go ahead. So,
Do we still have a problem with him trying to communicate, though?
no, he didn't want to have any communication. This gentleman comes over to the place and starts busting the windows.
I will say the complainant came to the place where the defendant was staying. Like, he initiated the contact in the situation.
And what's alleged is, and it's the last clause, or maybe two clauses, it says, a place specifically described in the order, to wit, the residence of a protected individual, namely Mark, and it should say McWilliams, but it says Mark Williams. So it's, in order to meet this charging document, it would have to be that gentleman's residence, and he does not reside there, as by his own representation to the state. And so I'd ask that, and I know it's a very unique situation.
How do we go forward, though? If I find no PC, how do we go forward? No.
Well, goes back out on bond while we prepare our defense to the initial charge of assault, which I think they've seen quite a bit by way of background about Mr. McWilliams.
How do we know that this isn't going to happen again?
Well,
I will say, I'm not sure where Mr. Byer will be staying if he were to get out on bond, but the witness, Shannon, she is no longer living in her apartment as of tomorrow. So that address it won't even belong to any of them as of tomorrow.
Do we do a no contact with both?
I don't we would do no contact with the witness, with Shannon.
Shannon?
But I would ask no contact with Mr. McWilliams.
You are now in a relationship with Shannon, right?
That's right, Judge. But yes,
So,
I've instructed him, just let me answer for him, Judge. But he is in a relationship with Shannon, that's right. And he moved here from Hawaii to be with Shannon, and the ex-husband takes issue with it. And the ex-husband has a very violent history with Shannon. And so, long-term, we think there'll be issues with case 1 even. But I understand that that's not really we're not there yet. I think the question is what to do if he is out. I do think, obviously, no contact whatsoever in any form, shape at all with Mr. McWilliams is appropriate, and that is what existed. Unfortunately, the state can't even reach McWilliams because he doesn't have a phone number that is even good.
have you run an NCIC check on this McWilliams guy?
We can see his in-county criminal history, but I can run a new check on him.
Do you see, I mean,
And I don't want to be
Pretty
incorrect,
expensive.
but I think he's got violent history with Shannon. But maybe Judge, when you get to be my age, it's hard to remember all the details. But I think I recall that, but maybe I'm mistaken. I don't want to represent something inaccurate.
you have inherited a dangerous situation. And Mr. Bio, you need to be very careful. You know, if you are in a relationship with someone and they have another person that's in their life that's like this, you could be the bearer of bad times. So you need to be very careful. You're in a very volatile situation. So you need to be careful going forward because it really could just could go out of control. You may need to get a protective order yourself. You know, it's very possible that you may need to get a protective order. So just be careful. You're in good hands. You ever have any issues, just reach out to Brian. We can always help you out as well. I'll find no PC on the violation of a protective order, but just be careful because
This is where legal drama meets soap opera. A love triangle, violence, and protective orders. It's a powder keg. The judge is basically saying, you're walking into danger with eyes wide open. Question for you. Should courts step in more aggressively when personal relationships become this legally explosive?
if an officer doesn't know any better and they come up and they see that have this open assault, they may never take your word. They may never even speak to you. They'll just put you in county. So you gotta be careful. You know, you're in good hands. We'll help you out for as much as we can. Okay? Okay, so I'll find OPC on the,
And I think Judge Wood,
on the violation case. And I'm not gonna revoke your bond on the original assault case, Mr. Bio, but you gotta be careful, man, you know?
and Judge, I think you should also have him give his updated address to pretrial would be appropriate as well.
Okay. And I think there's probably somehow make a notation in everywhere so that we know where Shannon lives. You don't have an address for, McWilliams, so I don't know how we're gonna handle
Well,
that.
I think the
but-
protective order does say any address where McWilliams does reside. So whether or not, I guess that'd be a notice question, but we know not to go anywhere where he lives.
I think the issue is whether this other person's gonna now be, Okay.
You understand all that?
Do you have any questions? Just be careful. Life's too short to live either in a 6x9 box or be 6 feet under because you got other people that have just be careful. All right.
Thank you, Judge.
Good luck. Good luck, Mr. Bio. When does it expire? Do you want me to amend this if this is where he's going to go live?
Well, I think he's moving out tomorrow. Well, she's moving out tomorrow.
Yes, Judge, she's being evicted.
I know, but
Well, yes.
Smoke
Sure.
tells
If
him
he
that
goes there tonight.
to this place. You're telling me that he lives there, right?
Well, I'm telling you that McWilliams doesn't live there. And,
No, but you're also telling me that he lives there. I mean,
well, he should have the right to be there, yes. And
where's he gonna go with that?
well, let me find out. I'll give you the correct address.
And then, because then I'm gonna take this off if he's gonna go back here.
Yes,
Mr. Williams, you're charged with failure to stop and give information. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement. They're offering you 3 days in jail, credit for the 2 days that you've done. Was there any restitution in this case?
No, Your Honor.
No, there wasn't.